Hey everybody, welcome back. First of all, I'd just like to start by saying I'm sorry for putting this video out so late, but today we will be finishing the bail series with the last video in this given series, and hopefully it'll tie a clean ribbon on the entire topic. If you haven't seen the first 3 videos, I will link them in the description box and on the screen for your convenience. Without any further delay, let's just get into the video. The term bail under criminal law is actually derived from the term bailment under contract law. Interesting fact, right? However, the definition of bail, bailable offence or non-bailable offence is not clearly provided in either the Code of Criminal Procedure or the IPC or anywhere else. However, the exact offences which fall under the category of bailable and non-bailable are given in a schedule at the end of Indian Penal Code. Column 5 of classification 1 of the first schedule in the Indian Penal Code provides whether an offence is bailable or not bailable regarding the offences which are under the Indian Penal Code, and the classification 2 deals with statutory offences or offences which are in other statutes that is not the Indian Penal Code. So those statutory offences, whether they are bailable or not, is given in classification 2, and classification 1 provides whether the Indian Penal Code offences are bailable or not. Phew, that was a mouthful. Moving on. Section 2A of the Code of Criminal Procedure also provides exactly what I just said, that bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, and non-bailable offence means any other offence. So section 2A and the schedule behind Indian Penal Code will tell you which of the offences are bailable and which are the offences which are not bailable. Section 436 to 450 of the Code of Criminal Procedure deals with granting of bail and bail bonds in the criminal cases. And section 2A along with section 436 to 450 of the Code of Criminal Procedure combined with the schedule behind Indian Penal Code is actually fairly simply worded and just requires a reading of the bare act. All the other complicated areas in the case laws we've already dealt with in the previous videos. We also discussed the concepts of surety, security, etc. in the last video, so please do yourself a favor, check them out. And the only other thing which we need to keep in mind is that granting or not granting of bail requires application of judicial mind, as the accused has a right to be free unless proven guilty. But justice or the interest of society requires him to be detained, so he doesn't cause any further damage and the interrogation and investigation can be conducted efficiently. So this requires a fair amount of balancing by the judge involved, because the rights of the accused versus the rights of the society and the expectation of society have to be balanced out very delicately. The Supreme Court in many cases has held that bail is the rule and jail is the exception. One such instance was in the case of State of Rajasthan, Jaipur versus Balchand alias Baliye, which was decided on 20th September 1977. If the offence is shown as bailable in the schedule at the end of Indian Penal Code, then the accused has a right to bail, and the police, after arrest and other formalities, will offer bail to the accused then only. However, in non-bailable offences, this balance that we just spoke about becomes all the more important, as the accused does not have a right to bail, and then the decision to grant bail becomes entirely discretionary and depends on the application of judicial mind. The decision to grant bail can depend on a myriad of factors, for example, the gravity and the nature of the accusation, the person's background including history of previous imprisonment, if any, the possibility that the applicant may flee from justice, or if the accusation against the accused has been made out of personal vendetta and is not accompanied by substantial or substantive evidence. Thus, granting or not granting a bail requires a fair application of judicial mind to come to the conclusion. And with that, we end our bail series. We are still looking out for what to start next. So if you have any suggestions, requests, leave them in the comments, and we reply to all our comments. And enjoy our videos. See you next time.